Everyone. Good morning to some others. We want to welcome you to the Ironworkers Impact National Safety Call, first one we've had this year. It's great to see you all here with us. We've got a really great topic today. We're going to be digging into the OSHA General Duty Clause. There's been a widespread misunderstanding pertaining to the OSHA General Duty Clause and citations that are being issued more frequently in construction and industrial workplaces. The Ironworkers Safety Department has received calls from employers, safety personnel, local union members regarding OSHA citations issued for alleged workplace hazards and questions regarding OSHA's discretion and use of the General Duty Clause for common steel erection and reinforcing rebar steel activities. So we've got three guest speakers with us. I will introduce them here in a little bit. They are all experts in the field, and we really look forward to some great discussion as we dig deeper into this. I would ask, as always, that if you have a question for us, we're going to do our best to make sure that we get to your question and get it answered. I would ask that you use the Q&A box or the Q&A tab that's there. There's also a chat tab. I don't have the time to monitor that, so you can certainly talk amongst yourselves through the chat tab, but any question you'd like answered, and we'll do our best to get them answered, we'd ask you to use the Q&A tab. So with that, first up is Eric Dean. He's going to say a few words. Eric is the General President of the Ironworkers and always gets on and thanks us for his time. So Eric, if you would.
Hi, everybody. We're trying to share our screen here. We're coming live from headquarters, myself, Steve Rank, and our General Secretary, Ron Pixa. To all the safety subject matter experts, to all the contractors, and to all the union officials, I always thank you for taking the time out of your busy schedule to, gather monthly, quarterly on important topics that affect our industry. Today's topic with this General Duty Clause is something that affects any type of contractor we have in the industry, from the shop fabricators all the way out to the specialized niche contractors in our field. And we've gathered some of the best safety subject matter experts to help you navigate. Unfortunately, I have other duties, but I just can't let a meeting go with a gathering where I see 64 people on the screen, and I know there's multiple people on some of the screens, come together for the betterment, safety of A, your employees, B, our members, and just the construction industry as a whole. So to all the subject matter experts, thanks for your time and devotion. And to everyone else, thanks for being here. And Steve, I'd like to thank you and your team. And my right-hand guy, Ron, the General Secretary, is going to stay with you for the rest of the topics and fill me in. And I'm going to politely adjourn myself. But thanking you just for your time. And Pete, I can't thank you enough for just keeping safety on the tip of our tongue. It's Steve's job and the safety department's job, but as an employer, you've taken that added interest. I can't thank you enough for running the point on these projects. So thank you all. And to the woman behind the scenes, Christy, our safety department administrator, I thank you for all the work you do as well. So thanks.
All right, well, thank you, Eric, for that. So again, our topic today is going to be the OSHA General Duty Clause. We're going to hit a lot of points here. We're going to review OSHA's General Duty Clause standard, when the General Duty Clause can be used, OSHA's instructions to compliance officers, OSHA's burden of proof for issuing citations, reasonable foreseeable hazards, corrective measures and abatement steps, actions by state OSHA plans, and case history governing General Duty Clause. So our three panelists are experts in their field. I'm going to go ahead and do a little introduction here on each one of them. First is James J. Sullivan. He's the co-chair of the OSHA Workplace Safety Practice. Jim served as chairman of the Occupational Safety and Health Review Commission. Jim was first appointed by President Trump to fill the portion of a vacancy in May of 2017 and was later appointed as chairman of the agency and confirmed by the U.S. Senate in July of 2019. As chairman, Jim was in charge of an independent quasi-judicial federal agency that is not a part of OSHA or the U.S. Department of Labor, but conducts trials and appeals over litigation brought by the U.S. Department of Labor against employers. During his tenure, he participated in several landmark decisions, including cases involving OSHA's process safety management standard and OSHA's use of the general duty clause in prosecuting cases against employers. Next up, we have with FDR Safety, Steve Hawkins. He is currently the Chief Operating Officer of FDR Safety. Steve previously served as Deputy Commissioner of the Tennessee Department of Labor and Workforce Development and as the Assistant Commissioner for Tennessee OSHA for 7 years. Also with us is James Stanley. Mr. Stanley brings unmatched expertise to counseling clients on workplace safety and health rules and regulations. He successfully dealt with OSHA and health issues in both the public and private sectors. And he was a former OSHA official, including Deputy Assistant Secretary of Labor for OSHA, along with being Vice President and Corporate Director of Safety for AK Steel. He's had a long history with OSHA, worked there for many years, and I can tell you that Mr. Stanley's a great friend to the iron workers and impacting the employers that hire him. I can tell you that that he was integral. We had an issue with where the general duty clause was used against us in a steel-toed boot issue, and his hard work, along with that, as Steve Rank, caused that citation to go away. So with that, gentlemen, we look forward to this time. Again, as we go along, I'll speak up as questions come in the question and A box, but the floor is yours.
Pete, am I on screen?
No, the slide is, but we certainly hear it.
Thank you for that introduction, Pete. My name is Jim Sullivan, and I thought that I would kick this off for Jim Stanley and Steve by talking about a very interesting general duty clause case that arose in 2012. Some of you may remember the case of this killer whale named Tilikum, who in SeaWorld in February 2010 pulled a female trainer under the water during a performance and killed her. Surprisingly, OSHA cited SeaWorld under the general duty clause with two what's called willful citations. Most of you may be familiar with the different characteristics of a other than serious, willful classification. There was a trial held before the administrative law judge, and you heard in my introduction from Pete that these trials are conducted by an agency that is not part of OSHA. And this is a real problem because everyone thinks that the Occupational Safety and Health Review Commission is part of OSHA. It is not. It is a completely independent group of judges. And when the act was passed in 1970, the statute was passed, they did not want to have the judges in the same agency as the prosecutors. You may be familiar with the NLRB. The prosecutors and the judges all work for the same agency. The Review Commission is independent, but unfortunately, because they use that name, everyone thinks that it's not independent, even to the point when you're being interviewed by the United States Senate to be confirmed as a member, they think it's part of OSHA. So unfortunately, we have to make that point every time I speak. So this case kind of surprised SeaWorld, and they went to trial. An administrative law judge from the Review Commission affirmed the citations, although he reduced the willful characterization to 2 serious citations. SeaWorld then went out and hired a person by the name of Scalia, Justice Scalia's son, Gene, who was our former Secretary of Labor under the Trump administration. He was at a large law firm. He's back at that law firm, and he handled the case before the United States Court of Appeals for the DC Circuit. And OSHA won in that case. They defeated SeaWorld despite Mr. Scalia's best efforts. But it's interesting to see who were the judges. The judges were Judith Rogers, Merrick Garland, and Brett Kavanaugh. Okay. And in this case, Brett Kavanaugh filed a very blistering dissent from the holding, which upheld OSHA's citation of SeaWorld, essentially saying they could have done things to prevent this this terrible tragedy from occurring. And now Justice Kavanaugh said, you know, I'm not sure when the statute was passed in 1970 that they really were thinking about this type of use of the general duty clause. And he went on to cite the NFL. As most of you know, the NFL is covered by OSHA. Have we ever seen OSHA cite an NFL team because of some inherently dangerous workplace issue? No. How about NASCAR? All these other types of engagements where you are assuming some risk as an entertainer or a performer, Justice Kavanaugh thought was beyond the scope of the general duty clause. But that's not the case. The DC Circuit upheld the citations in this famous case, and it was not appealed to the United States Supreme Court. So then fast forward to another case based in Florida. In this case, it's called Integra Health Management, and this was a case that I was a member of the commission when it was decided. And this case involves an issue of whether or not a homicide at a workplace could be covered by the general duty clause. There's a lot of controversy in this matter. It's never been decided before the Review Commission before that an act of workplace violence like this could actually be involved. But in fact, we found, because there's 3 separate opinions in this case from 3 separate commissioners, but we found that it could be cited on the general duty clause on these specific and egregious facts where this young lady, recently out of college, 25 years old, no prior experience in social work or anything else, goes to work for a company. The company's job is to go to see people at their homes who are not compliant. They're not going to their doctor's visits. They're not taking their medication. It's costing their insurance carriers lots of money for these expensive emergency room visits, et cetera. So they came up with this plan. We're going to send these folks, these social workers, to see them at their homes to see if they can get them to take their medication, to go see their doctor, even sometimes drive them to their doctor's appointments. Well, this poor young lady went to see this gentleman. The second time she went to see him, she wrote in a report, and her supervisor read, he's acting very strange. He had cardiovascular disease and schizophrenia. Unbeknownst to the employer, the employee, this person also had a 15-year history of being in prison for assault and aggravated battery. So he had this history of violence. And on her last visit to see him, after she told her employer, look, I'm not going to go inside. This guy gives me the creeps. He says some strange things. I'm not going to interview him inside unless someone else from the company goes with me. They didn't send anybody else with her. And out on the front yard, he came out, chased her down the front yard, stabbed her 9 times. A passerby found her after he went inside and took her to the hospital, and she died at the hospital. So OSHA cites this employer, Integra Health Management, for this homicide. Everyone from the employer industry is very concerned. Is this a random act of violence? Is this where we're headed with the general duty clause use of this? We don't have a workplace violence standard. At least federal OSHA does not. California OSHA does, with limited to social services and healthcare employers. So anyhow, the bottom line was that under these set of facts, the commission found that it was reasonably foreseeable based on the facts here that this might have occurred, especially all the information she gave back to her employer after her first 3 visits to visit this man who eventually killed her. And it was preventable, which is part of the reasonably foreseeable analysis. So in the last case, just to give you again a sense, because we're going to go through the law, we're going to go through what OSHA has to demonstrate to cite employers on the general duty clause, is the Sturgill roofing case, which we'll talk about, I think, at length today, because heat stress is now the big emphasis at OSHA. And in this case, it was a small roofing company with only 36 employees who had a day laborer on his first day in the job collapse on a roof. And then 3 weeks later, he died in the hospital. The coroner said it was heat stress. The judge found in favor of OSHA. The review commission, in a 2-to-1 decision in this case, with the current chairperson dissenting, the majority found that in fact, this particular case, OSHA was not able to prove two things. One, that a hazard existed, as you'll hear later from Jim Stanley, and two, that they had any knowledge that they were facing this hazard. Simply put, heat is everywhere, okay? There's no heat stress standard in federal OSHA, and they did, in this particular case, what was reasonably necessary. They gave shade, they gave rest, they gave water. What they didn't know was the pre-existing conditions that this poor man had, including diabetes and a heart condition, when they put him on the roof to give him the easiest job that day on the roof, which was simply to dump the materials they were ripping off down a slide into a dumpster. So it's a very important case. We're going to be coming back to at least Integra Health Management and Sturgill Roofing as we go through and talk about examples that your workplaces might be confronted with as you get hit with a general duty clause violation. If you go to the next slide, please. So again, Pete had said something. I didn't want to correct him during this, but he said the general duty clause standard. The general duty clause is not a standard. It's the opposite of a standard. The general duty clause is simply a clause in the statute, okay, that was when the statute was passed 50 years ago. They just used what I think is called aspirational language, essentially saying the purpose of this act is to have employers have a workplace which is free of recognized health and safety hazards. The problem is that now has morphed into something more than that. What it has morphed into is the use by this general duty clause as a catch-all by OSHA when they can't find a standard that applies. If a standard applies, you'll hear this a couple times today, they cannot use the general duty clause. Okay, it's only when the standard does not apply. But the problem is that this use of it as a catch-all has been becoming more and more prevalent because, frankly, the average length of time it takes for OSHA to issue a new standard is 7 years from the time they begin to the time they end, because they have to do it under the Administrative Procedure Act requirements of notice and comment, stakeholders' involvement. So when they found out that these standards take so long to issue because of litigation that arises by the special interest groups that are involved in these proposed standards, and you'll see this coming with the new heat stress standard that's going to be issued or attempt to be issued soon, they said, well, heck, we do have the general duty clause. So especially in the case of a fatality or a serious injury, if we can't find a standard applicable, we're going to cite them anyhow under the general duty clause. The problem with that is, at least with a standard, employers know what their legal obligations are. They know that if there is a certain amount of feet for fall protection, or a certain amount of measurements that a ladder has to have, or a certain amount of health standard, limitations on how much you can breathe, not breathe, noise, there's a standard. Here, how do you know what your legal obligations are? Some employers complain, frankly, that the first notice they ever received of what they were obligated to do was the citation. And that's not really, I don't think, what the Congress intended in 1970 when they passed that, because the purpose of the statute is not to guarantee employee safety and health. Some of you may know this legal concept of strict liability. Strict liability means irrespective of whether there's any foreseeability of an accident or an injury to occur, you're liable. That's what the workers' compensation statutes do. Doesn't matter who's responsible for that employee's broken arm, the employer pays because the statute has created a compact with essentially strict liability. The OSHA statute was not intended to eliminate all risks of harm, only those risks that are likely to cause serious harm, and only those risks that are really foreseeable. Next slide, please. So OSHA has to prove when there's a standard only that the standard applies, the employee failed to comply with the standard, the employee had access to the standard. I'm sorry, that should say the hazard. The employees had access to the hazard, and the employee knew or could have known to exercise reasonable diligence of the existence of the hazard. Under the general duty clause, on the other hand, OSHA has to prove more. They have to prove that there is a hazard which is recognized, okay, recognized by the employer, and which is likely to cause death, or serious physical injury. And that's really what we're going to spend some time talking about today. Just one last slide for me, and then we'll move on. Two concepts. Next slide, please. The hazard. Okay. What is a hazard? In the Integra Health, in the Sturgill roofing case, the majority held that OSHA did not prove that the heat on that day posed a significant risk of harm. They just assumed that because it was above a certain temperature, and they used a chart that was published in a magazine in the late 70s, that therefore they could prove there was a hazard. Well, they couldn't prove there was a hazard. And then recognition is the other important concept you'll hear a lot about today. Did the employer have actual knowledge of the hazard, or through a general understanding of the hazard in an employer's industry? That is, you can sometimes use this now. They're going to be using these things like manuals for equipment, employers' own programs and training. That in the case of the Integra Health Management case where the young lady was stabbed, OSHA used the training programs to demonstrate, the employer's own training programs to demonstrate that they had a general understanding that their employees were at risk of assault when they went to see these individuals. So that's my kickoff for what we're going to talk about today, and I'm going to turn it over.
Say, before we move on, we have a question, and I think I'll go ahead. I'd like to ask it now.
Okay.
We were asked, and they asked it of me. I think this is going to be a great question for Jim Stanley to weigh in, but I'll go ahead and read it. He said, Mr. Hayes, can you elaborate on the steel toe boot issue you mentioned at the opening, and how the Ironworkers International and others were able to help? I don't know if other employers in the call understand the general duty clause and/or anything relative to steel toe boots, much less how they can help or get help from the ironworkers. So Jim, maybe you want to answer that question for us? Jim Stanley? Maybe Jim is muted.
He is muted.
Mute. How's that?
Okay.
There we go. Now we hear you, Jim.
Okay. In OSHA standards, there is a requirement for protective boots, safety boots. It normally talks about steel-toed shoes. Their metatarsal guarded shoes are a form of a safety shoe. Everybody knows that, but it's primarily to prevent injuries from the metatarsal portion of your foot, the top of your foot, if you drop something on it. The steel-toed shoe doesn't do anything for that, but in a lot of industries, they require a metatarsal guarded shoe, such as the integrated steel industry. In this particular case, it's the first time anybody had ever heard of it. OSHA, they were unloading some steel shapes from a pallet or from the ground that was placed on the ground, and one of the shapes fell over slightly and caught the top of a worker's foot, and OSHA came in and used the general duty clause to say that, well, there's no standard for it, but it is a recognized hazard. Well, and you'll see when we start talking about this, where was it recognized? It wasn't recognized by the employer, Red Cedar Steel. It wasn't recognized by the ironworkers, the union. It wasn't recognized by the industry anywhere. But basically, they got down to it's a common sense regulation, and you'll see we'll talk about that a little bit. But we were able to have some meetings with OSHA on an informal basis and a formal basis, and explained our position, and they were very reasonable, and they understood, and they considered it, and they withdrew the violation. That's how it worked.
Jim, this is Steve Frank. I have a comment there. One of the parts of that question was, how do the ironworkers rectify this? Well, with the support, we have one of our trustees here. We have what we call a regulatory defense fund. Every year, we have a fund that's used for cases like the steel-toed boots, where if our employer loses this case, it could set bad case precedent for us. So we have a regulatory defense fund to answer that part of the question that we can use on cases where it's multiple lift rigging, decking, rebar issues. And I've worked with Jim Stanley and his company many times to resolve these things behind it. So that's how the ironworkers help to resolve this, is through the support financially through Impact, our trustees, to have a fund there to fight an issue that could affect all of us. So I hope that helps a little bit on answering that. Thank you.
So let's go to the next slide, Wayne. So we're going to go through these, and Jim Sullivan and Steve Hawkins are going to chime in as they see fit. And if there's questions that come up now, please write down your questions if you want to hear all this, and then we'll have plenty of time at the end to answer as many as we can. Or if you want to send them in now, maybe Pete will find some time to answer them during this presentation. But my first advice to everybody is, there is the OSHA Act. Ask yourselves, how many out there have actually read the Act? You can go and Google it, OSHA Act, OSH Act, and it comes right up. But in that Act, which was signed in 1970, and by then President Nixon, this Section 5A1 is there. And it says what you're seeing on the screen, that every employer has to furnish each of his employees employment in a place of employment that are free from recognized hazards, that are causing, and big word, likely to cause death or serious physical harm to its employees. So let's go on, next slide. In general, the Review Commission, as you heard, and the courts of all, they've set some precedents here and established these elements, these 4 elements that are necessary for OSHA to prove a general duty clause violation. Again, I want to stop here and tell you I am the biggest fan of OSHA. I am not a critic of OSHA. OSHA was very good to me for 26 years. As a matter of fact, the first of every month I get a nice check from them. They have made a tremendous change in construction safety and health throughout this country, to the fact that, in my opinion, the construction industry is the safest type in all the other countries in the world. No one has a safer industry, construction industry, than the United States. And that is because employers throughout this country have taken up the banner and have done the right thing in almost every situation. But in this particular case, before we get to this, I want you to keep in mind a general duty clause violation. I'm going to make it up. We go to a construction site. There are 2 scissors lifts on the construction site. They are both working out in the field, outside. And they are, one of them, they're both up in the air 15 to 20 feet doing various work. And one of the lifts freezes, doesn't work anymore. The individual cannot get down. It will not go down. The other aerial lift guy goes over, operator goes over to him, and he gets as close as he can. And the one employee decides that, or they decide together that he's going to climb over the rail, and he's going to climb over the rail, the second one, and he's going to get in there, and they're going to get down, and they'll get maintenance to fix the machine. Well, in so doing, the worst nightmare occurs, and he slips and falls to the ground and very seriously injured and may have expired. I'm making it up, so I'm going to say it's seriously injured. So keep that scenario as we go through that. OSHA comes out and cites general duty because there is no standard on scissors lifts. OSHA has stated in some interpretations that they believe that a scissors lift is a scaffold, a temporary elevated platform. But even if you went to the scaffold standard, it doesn't mention scissors lifts anywhere. So the employer failed to keep, they have to, the necessary to prove, they have to prove that the employer failed to keep the workplace free of a hazard to which the employees of that employer were exposed. Key word, employees of that employer. The hazard was recognized. The hazard was causing or likely to cause. Definition, that's a definition, by the way, of a serious violation. It's one of the entities. It's not based on probability. It's if an accident occurs, is it likely to cause death or serious physical harm? If the answer is yes, it's a serious violation. If the answer is no, it's not likely to do that. The issue is then considered other than serious. And finally, there was a feasible and useful method to correct the hazard. A general duty citation must involve both the presence of a serious hazard and exposure of the cited employer's own employees. Next slide. You heard the definition before of Jimmy in the Sturgill case, but here's the definition in OSHA's FOM. A hazard is defined as a workplace condition or a practice to which employees are exposed, creating the potential for death or serious physical harm. And such a condition or practice must be clearly stated in the violation description, by the way. It's not good enough to just say, hey, you didn't provide a workplace free from recognized hazards. In any issued citation with a general duty clause violation in it, it's got to say exactly what the condition or practice was that wasn't complied with. All right. So also the hazard must be a condition or practice that can reasonably be abated. If it is not feasible, OSHA has a real tough time in winning their case. And many OSHA general duty clause violations are on highly technical issues that are not in the standards in any way.
Hey, Jim Sullivan.
Yep.
Two things. Tell everybody what the FOM is, because you just talked about it.
Yes, it's a living document. It was issued in 1973. It's instructions to OSHA's compliance officers how to operate. It's been changed numerous times, brought up to current. I think the last one was in 2020. I remember myself and a gentleman by the name of Barry and Zettler in the national office. We rewrote the violation section, chapter 4, in 1989, and that's been changed numerous times since then. But
so
that's
the field operations manual for the compliance officers. One other point on this slide, the last sentence, the hazard must be a condition or practice that can be reasonably abated by the employer. The general duty clause can only cover hazards that are preventable.
Correct. Next slide, Wayne. These violations aren't intended to allege that the violation is a failure to implement certain precautions, corrective actions, or other abatement measures. If you get a general duty clause violation that says you failed to provide appropriate personal protective equipment, therefore you're in violation, that can't be cited that way. That's an abatement method. Particular abatement methods cannot be cited. They can only appear in the note at the bottom of it, that they are recommending, OSHA is telling you, feasible ways to abate that. If there are no feasible ways to abate it, they cannot cite it. I hope that's everybody gets that, because it is a big deal. I could say that many of the general duty clause violations I've seen are written correctly, but there are some that cite the abatement method. And when that occurs, that's a reason to contest, believe me. Next.
One more point, Jim Stanley. The feasibility of abatement should always be addressed by the employer when they get this. Just because OSHA has said this is proposed abatement, don't assume that they can prove it's feasible.
And we'll probably get one or two questions on that, Jim.
Okay.
The hazard must be reasonably foreseeable. Those two words, write them down. It's not only general duty clause violations, it's guarding violations, it's confined space violations, it's all kinds of violations in OSHA. They have to be reasonably foreseeable to be cited. This is case law that has come out over and over and over again. All the factors that could cause a hazard need to be present in the same place or in the same time to prove foreseeability of the hazard. If it is not reasonably foreseeable, I will give you an example in machine guarding. There's a belt and pulley underneath a table. In order to reach it, you got to get down on your hands and knees and climb under the table to reach that belt and pulley. It is not guard. It is, if it's the only people that ever go there, not the operators, nobody else, is the maintenance people. And they are required, of course, to lock it out before they go there. So it is not reasonably foreseeable that anyone would be exposed to that hazard. That is not citable. That guarding is not citable by OSHA. Next.
Hey, before we move on, we've got a question. Someone's asking, what does feasible mean to OSHA? So maybe a little background on the word feasible.
That's a really good question, and I'm going to let Steve Hawkins answer it.
I got the answer to that actually, Jim.
Okay, go ahead.
When Subpart M came out in 1995, I believe, they have a definition of feasible or infeasible, means impossible. If it's infeasible, it's impossible. That's the closest definition to feasible that's in the standards, is the one infeasible, which they determined to mean impossible.
1926, 500, is that where you're talking?
Yes, sir.
Good. Steve, any other words?
I got a legal answer.
What is it?
Okay, so what the commission and the courts have said is, if you're going to challenge the feasibility of proposed abatement, you've got to show, OSHA has to show that it would be effective in materially reducing the incident of the hazard. Okay, they don't have to show that it would eliminate the hazard, but it has to materially reduce it. And many times they can't show that. They can show that, for example, well, if you had this additional training, it might do the following. Well, maybe it wouldn't, okay? So when you get a citation, if you're an employer, focus on whether or not they could demonstrate that what they're asking you to do will, in fact, materially reduce the hazard. Many times it will not.
So just to add to what Jim's already said and Steve Rink said, I will tell you from a practical standpoint, OSHA, the people in the field, not necessarily the OSHA attorneys, but the people in the field who write these and who enforce these, unless they're contested, will do just as Steve Rink said. They will say that feasible means it's possible. Not is it easy, not is it commonly done, not is it, we can do this without materially affecting our business or how we do it. Feasible means it's possible. Can a person do this? And if the answer is yes, can this be done? Then generally speaking, OSHA is going to say that's feasible, even though they might single out an employer and nobody else in this industry does a certain thing. But if they issue a general duty clause violation and they and they say that their abatement is feasible, then unless you can test it, it stands. I will remind everybody on the call, though, that because OSHA, when they issue a general duty clause violation, they have to include a feasible abatement, one, not the one, but a one. And so when you read these, if you ever are in receipt of a general duty clause violation, just because OSHA says you fix it by doing A, B, and C, that in no way does that mean that's what you have to do. OSHA has to tell you there's a possible way to do this. OSHA does not. They have no ability to enforce A, B, and C, the 3 ways to fix the hazard that are included in a general duty clause violation. It's just a legal requirement that they have to provide that. So if they tell you, you got to do backflips, but there's an easier way to accomplish and eliminate the hazard, you're welcome to do it your way. You'll have to give them an abatement letter, but you don't have to assume that they said you have to do A, B, and C, and therefore you have to. They have to tell you there's a possible way and give you an example, and then it's up to you. If you accept the citation, you develop the best way to fix it. You don't have to use their way.
That's really important for economic feasibility, which is an issue. If you can demonstrate there's a more economic way to abate or materially reduce the hazard, then you're free to do that, as Steve just said, because feasibility involves economic infeasibility as well. So don't just assume that their proposal is the only way to do it.
And one other thing, just remember that administrative corrections have to be accepted. In other words, if you can remove the exposure to any and all employees, then that is abatement. No exposure, no hazard. And that can also be a way to correct. Next slide.
So before we jump in, we got another question here. We were asked, we'll go back to that belt and pulley example you gave. So if there's an open belt and pulley underneath the machine, and someone was to go under to retrieve a tool that was dropped and get caught in the belt, then what?
Well, obviously, that is cleaning. That is cleaning up, or that could be considered service or maintenance. And when you're doing that, you have to lock out. The example that I'm giving is that you had to climb under there significant distance. So when you're in there, let's say doing a cleaning operation, and cleaning operations are considered service under the general industry standard, that would be something that the control of hazardous energy, you would have to lock out that. And why wouldn't an employer, if they know they have a belt and pulley under there, why wouldn't they have a program that requires you to do that? So
I have this exact case almost involving a saw where an employee went in and got caught and got seriously injured. They settled with OSHA and they put a barrier in front of it. And guess what? Another employee went around the barrier and got caught in the saw system again and got seriously injured. The question, and they got cited under the general duty clause. And the reason is because they're saying, well, even though only your maintenance people go in there after they lock it out to clean up, you should have anticipated that this guy would walk around the barrier and go in there. Why he went in there, we have no idea. So it happens. Jim is right. They're going to cite you under the general duty clause, probably, because there's no guard that was necessary to prevent this from happening. But you have to look at all the potential defenses, including employee misconduct, or including whether or not it would be reasonably foreseeable for a reasonable employer, given all the circumstances, to assume that an employee would go in there and put himself in danger in that pulley system.
And that's it. The reasonable foreseeability is just all over the case law. So in response to whoever put the question in, if that goes on all the time, people drop stuff in there or kick it underneath the table and they're going in there, then it's reasonably foreseeable. And then
Right.
you have to guard it. Absolutely. Next. The recognition of a hazard can be established on the basis of an employer recognition. There's one. Industry recognition. That's two. Common sense recognition. Three. And what we're talking about is the recognized hazard under a general duty clause. So the use of common sense as the basis for establishing recognition is limited. That should be only used by OSHA under very, very special circumstances. Recognition of the hazard must be supported by evidence and adequate documentation, and I'll give you some in the next slide.
Again, just to point out to everybody, we're talking about the general duty clause. If you get cited under a standard, OSHA doesn't have to prove this because the standard establishes the hazard.
Correct.
Very
Next.
important distinction.
Say, before you get into the next one more question here. We were asked, what is the difference between practical and practicable as defined by OSHA, and how does that affect employees and keep members safe?
That sounds like a legal question.
It sure does.
Well, I'm not familiar with the definition of practicable, but maybe I could guess as to what the questioner, or maybe ask the questioner, Harvey, to give me some more information. But basically, when you're talking about trying to look at hazards under the general duty clause to recognize a hazard, okay, you're looking at situations in which it's preventable, okay? That is, we're looking for something that we could prevent from happening. But if there's nothing that you can do as an employer to prevent that accident or that injury from occurring, then you don't have an obligation to do anything. Okay, it's not strict liability. So I think I'm trying to answer the question without really understanding what he means by practicable. And thanks for throwing that my way, Jim Stanley.
You're welcome. So anyways, a recognized hazard, obviously, if an employer has actual employer knowledge of the hazardous condition, that's very citable. And evidence of employer recognition, written or oral statements made by an employer or management supervisory personnel before the OSHA inspection. If the OSHA compliance officer hears that, if there's admissions by an employer of that, well, we knew that could go on, that's recognized hazard, and that's going to be the end of it as far as OSHA is concerned, and they'll be documented.
Lots of employers, Jim, are afraid to do any type of audit or assessment or to look for hazards, because if they put something in writing that will be used against them later in this category, and I think we all agree that that's not a smart move.
Not smart at all.
You should be out there looking constantly for hazards, irrespective of whether OSHA can use that in this recognition test later on down the road.
And I like to stop here, and all three of us, Jim Sullivan and Steve Hawkins and myself, are in agreement in what I'm going to tell you right now. And that is the inspection process that an employer goes through to identify hazards or violations. I would say to you, throw away your OSHA checklist on violations. Get competent people to be on your inspection team and have them look for hazards in the workplace. If it's not a hazard, why are we wasting our time? What we need to identify hazards or potential hazards and get them corrected, rather than going through the minutia of a OSHA violation that really doesn't affect anybody. It's never going to hurt anybody. It's a very minor issue. Let's look for the hazards out there. If we do that, we're going to be in a lot better position to be able to show OSHA that we're a responsible employer and we are in fact doing what the right thing for our employees. And engage your employees. Employees know where the hazards are much more than somebody that's only coming out there once in a while. So that's just a side note.
Lots of clients ask for those checklists and we just don't provide them.
Employer awareness of a hazard can also be demonstrated by review of a company's memorandum, their safety work rules that specifically identify a hazard. They're going to look at all that to get your knowledge. Knowledge is a big deal. Awareness of the hazard, a big, big deal. In them being able to prove their case. And if they find it, they should prove it on that basis. Employer awareness of a hazard can be demonstrated by prior federal OSHA or OSHA state plan inspection history. If you got cited before for the same thing, it's hard to argue that you didn't know. Employee complaints or grievances or safety committee notes or any of that that's part of your operation that identifies hazards. That's it. Next slide. Recognized by an industry other than the industry to which the employer belongs is generally insufficient to prove this element of a Section 5A1. That is a big deal. Believe me, if I don't know how many times I have seen this in testimony where where they are referencing OSHA is referencing a industry standard that isn't the industry that we're working in. And this is their own words. What I just read you here, this is exactly right out of the field operations manual. A hazard is recognized if the employer's relevant industry is aware of its existence. Recognized by an industry other than the industry to which the employer belongs is generally insufficient to prove this element. Although evidence of recognition by an employer's similar operation within an industry is preferred.
Here's the simple example. So where the hazard is heat illness, okay? Excessive heat is the way they categorize it. And you are an employer that works in a boiler room or a steel mill that has excessive heat, okay? And you have a plan to deal with that potential hazard with your employees because they're susceptible to that heat exhaust or heat stress. But if you are an employer with employees that work in an air-conditioned environment or an air-conditioned warehouse or something like that, okay, they're not going to use the recognition by the employer with the heat issue in their programs against you because you're not in a similar industry that recognizes that hazard. Okay, that's an extreme example, but you can take it down further to more discrete examples.
Next slide, next slide. Common sense, I said before that common sense recognition isn't something that OSHA, they really got to be going, they must really want to cite if they get to common sense. And if industry or employer recognition of the hazard can't be established, hazard recognition can still be established if its condition is so obvious that any reasonable person would have recognized it. Let's take the example that we just talked about, the two aerial lifts climbing from one basket to another without any form of protection. To me, that's an open and obvious hazard doing that. And in that particular case, recognizable under the citation, for our citation. It should only be used by OSHA in a flagrant or obvious case. Next. The element in a Section 5A1 can be established to death or serious physical harm, obviously an actual death, but if an accident incident occurred, the likely result would be death or serious physical harm, then that's a serious violation. This one is hard to gauge. In some cases, OSHA, for instance, will cite a 6-foot fall, a 4-foot fall as a serious violation because death or serious physical harm could result. That's not the standard. The standard is likely to result. And remember, if you're working from a scaffold, OSHA allows you a 10-foot fall. If you're working an overhand brick, or you're working from a ladder 30 feet in the air, you don't need fall protection on a portable ladder. That is OSHA is allowing in certain circumstances falls. So whether or not a 4-foot fall would automatically be serious, I would argue that. But that's just something that you should consider. Likely result would be death or serious physical harm. If the answer is no, it cannot be a 5A1.
And also, there's the case of a freak accident. So the real legal question is it reasonably foreseeable to a reasonable employer presented with the same set of facts to assume that that 4-foot fall would have caused that serious injury? And that's the analysis, okay? It's not just that, okay, he did get seriously injured, therefore it was a 5A1.
All right, next slide. Well, we're going back into the feasibility again, and you can look at these three and read them for yourselves, but obviously the existence of measures that is feasible, available, and likely to correct the hazard. Evidence of feasible abatement measures indicate that the recognized hazard, the recognized hazard rather than a particular accident or incident is preventable. And we talked about it. So the examples down at the bottom there, the employer's own abatement method, which existed, that would be feasible, obviously. Implementation of a feasible abatement measures by the employer after the accident, that tells you that it is feasible if they do it afterwards, if they can do it. I just was involved in a case where it was a fall, and there was no JSA, and there was no task-based risk assessment. And after the gentleman fell, the company wrote up 12 different abatement measures that were all feasible that they could have done after. So feasibility, OSHA has to identify it, they have to prove it, but in most cases, it's not that hard for them.
And remember, if you have 12 different proposed abatements, you don't have to implement all of them.
You don't have to do any of them. You can do your own.
Right.
Next slide. This is in bold for a reason, because it's probably the most important thing here. The general duty clause shall only be used when there is no standard that applies to the particular hazard. And in situations where a recognized hazard is created in whole or in part by workplace conditions or practices that are not covered by a standard. So if we have a standard, but it doesn't cover this issue, that's a big question, by the way. That is a big question, whether or not that is citable under the general duty clause. And where you have a standard, for instance, the ironworkers standard is 15 to 30 feet for connectors. Most general contractors say 6 feet is what is going to be on their job. So the ironworker, if he wants to work there, he goes to 6 feet. But if a connector falls at 14 feet, that is not a violation of OSHA. And I hope that's clear to you.
Yeah, it's preempted by the standard. A general duty clause violation is legally preempted by a standard if the standard covers the same alleged violation. So they cannot do what Jim just said, which is to try to cite you under 6 feet when the standard says 15 feet.
Next slide. Not when a standard applies, not used to impose a stricter requirement than that is imposed by the standard. Very big deal.
That's what you just.
Not normally
example.
used to require additional abatement methods not set forth in an existing standard. Can't use the 5A1 in those 3 areas right there. You were going to say something, Jen?
Well, number 2 is exactly what we were just talking about, 6
Right.
feet versus 15 feet. Number 3 happens sometimes where they're trying to propose abatement methods that are not contemplated by the standard, okay? And so what happens in many cases now, you get a citation under a standard, and then you get a citation in the same citation under 5A1. So we're going to cite you in the Sturgill roofing case because you didn't train properly under the training standard for this heat illness, but we're going to give you a 5A1 because you didn't prevent this guy from dying 3 weeks later in the hospital. Okay, you'll see mostly 5A1s, sometimes with also separate citations under standards if they can find. And most commonly, it's those standards that are involving training, etc.
Next slide. Okay, what we're going to talk about now, and Steve's going to take over, Steve Hawkins, we went through, and he'll tell you. Go ahead, Steve.
Yes. So what you have on your screen now are some examples that I pulled from the OSHA website for the NAICS code for still erection. And it just so happens that the NAICS code for still erection and precast concrete erection is the same. And so, I first tried to pull these out, but they're so really applicable to the still erection industry that I left those. And so we're just going to look at some examples of general duty clause violations that OSHA issued to people in your industry. And so this first one, and I'll note the dates and the amount of the penalties over on the side. That's a very low penalty. And I will also tell you, as we start to look at these, things changed about 6 years ago when OSHA started requiring employers to report injuries that result in hospitalization, amputation, or the loss of an eye. And so the loss of the eye is extremely rare. Amputations, more frequent than loss of an eye, but it's not unusual for a person to have an injury and spend the night in the hospital. It's not a rare event, right? That can happen. And so you'll see a lot more of these general duty clause violations coming since employers were required to report those hospitalizations, and OSHA decided to investigate those reports of hospitalization. And so, you can think about there's lots of strange ways to injure yourself, right? We've all witnessed that probably in our, personally, right? You drop a glass or you hit your hand, you got a glass in it, the glass breaks, you cut your hand. There's a lot of ways to get hurt in the workplace that OSHA has no standard for. But I've got several notes I want to cover, but one is, as we get into this, OSHA is always under a lot of pressure to issue a citation certainly when there's a fatality, tremendous amount of pressure to issue a citation to do something, right? Even if it's not necessarily all that helpful, but to do something when there's been a fatality. And then by that in that same vein, OSHA also is under a lot of pressure to issue a citation if somebody gets hurt. Because I think personally, OSHA takes it personal. So if someone gets hurt in the workplace and let's say they spend the night in the hospital because they have a broken arm, it was multiple fractures. They got there late in the day. They had their blood pressure was high and they broke their arm. They're going to put them in the hospital, right? They're going to admit them to the hospital. The employer has to report that to OSHA. And then OSHA chooses to either respond with a letter asking you to, as the employer, to investigate it, or they send an investigator. So they send an investigator, a compliance officer. He goes out and says, okay, this relatively strange, uncommon event occurred and a person broke their arm as a result. Not something that OSHA has a standard for. It wasn't a violation necessarily in the workplace. It wasn't a machine guarding violation. It was something else that caused them to reach in. It could be they reached in between a tractor trailer and a dock as it was backing up to do something, and it broke their arm And so that can certainly happen. There's not a specific standard that says don't put your hand here, don't put your arm here. But that compliance officer is going to feel a lot of pressure to issue a citation because somebody got hurt. And if OSHA doesn't issue a citation, I think a lot of people in the public generally and within OSHA says, well, if we don't issue a citation, we're saying it's okay. And I don't believe that's true. If you don't issue a citation, that means there wasn't a standard for it and it wasn't a reasonably foreseeable event. We've all experienced in our careers, people do some things that are inexplicable. Most of us have children. That's how we know that kids do, people do, kids are people too, I guess, or teenagers. They're young adults, 18, 19 years old. And myself, I've done things that I didn't understand why I did them afterwards. Like, I can't believe I did that, right? So that happens in the workplace. Somebody receives an injury that they're hospitalized for. OSHA comes in and they feel compelled to issue a citation.
Hey, Steve.
Yep.
So this says the shackle pin used to secure a safety sling was not fully engaged. And people may be confused about what we talked about in terms of hazard recognition, okay? They said, well, wait a minute. We didn't know the shackle pin wasn't fully engaged. And that's not the recognition that we're talking about here. The recognition we're talking about here is if you did know or should have known that it was not fully engaged, is it recognized by you or your industry that that would not secure a safety sling and cause this accident? So I just wanted to make that point out. It's recognition of the hazard that was created by not having some way of ensuring that a shackle pin was fully engaged. And I'm
fully engaged, which means it's tightened down and maybe has a safety wire on the end of it or a cotter pin, right?
So that's why you gotta look for those hazards because they're not obvious sometimes.
And in this case, there was not a specific citation that required that, or not a specific standard that required it. So that's the first one. Let's look at the next one. I've got about 6 examples here, and then we'll wrap up, maybe 7. So here's an example. Gulf Shore Erectors was issued a general duty clause violation because employees were exposed to a struck-by hazard when they were lifting precast stairs. Now, Jim Sullivan will tell you, and Jim Stanley will tell you that should have ended right there, but it goes on to say without protecting the slings from sharp or rough edges, which really prescribes a specific abatement. And the violation is really not properly written in our opinion. But here it is that the sling was exposed to sharp or rough edges. And I'm assuming that an employee was probably struck by the stairs when they came loose because the sling hit something rough and the sling was cut, which allowed the stairs to move or strike someone. That's what this says. So we don't have a specific standard in this industry that talks about specifically about protecting slings from sharp edges. If we did, then that would be the correct violation that would have been the correct violation. In this case, there's not one, so they issued a general duty clause, and most of us generally know we're supposed to protect the sling so that it can't be cut if we're rigging up something. So let's go ahead and go to the next one. We have
just one note. There is a standard over in general industry rigging that talks about protecting slings from sharp and rough edges. But this is construction. That was general industry. General industry is a horizontal standard. Construction is a vertical standard. And there are people that would argue, of course, that when it doesn't apply, if there's a standard in the horizontal standard, that you could use it. But evidently the compliance people here didn't think that would fly, and they went with the construction general duty.
And the reason they did that is because they knew the employer's lawyer would argue about the applicability of general industry standards here.
Right.
Correct. And it's easier for them to do general duty clause because these cases many times settle, and therefore they don't have to fight that battle.
Next slide. So general duty clause violation for not wearing the seat belt on an all-terrain forklift, right? That's what the citation was issued for, $1,900 penalty. Also worth noting, almost $2,000 penalty was reduced to less than half of that at $975, right? Still was there was a formal settlement on this one. But an example, we've long debated about whether forklift operation requires the use of the seat belt. Here OSHA says that it does. Okay, let's go ahead and look at the next one. The next one, want everybody to look at this one. We all think of the hook, the safety hook on the latch, right, as being, in this case, the hook was broken. So at the 3rd story stringer, a hook connected to the rigging equipment had a broken safety latch. This condition exposed employees to a potential struck by hazard. Now, I would assume that there was an injury involved here, because I don't think OSHA generally is out looking for the, looking at each latch to see if it's equipped with a safety hook, right? And you see those, some of those are really heavy duty, some of them are super light duty. I have a small farm. I've got, slings that I use to pull something with that have hooks on both ends. They have the safety latch on them, and they're almost an afterthought and one use, and that little spring and the little cheap clip is broken and you're left with a regular hook, right? Oftentimes. So just an example of another general duty clause violation in the steel erection industry that OSHA said, this is a recognized hazard. They're supposed to meet all of the requirements that Jim Stanley and Jim Sullivan have discussed today, but we know that's often not the case, right? So let's look at the next one. Another general duty, notice that the violation was reduced, so it was settled in an informal conference. And it says, at prior times, employees were exposed to struck by hazards in the event that the employer had modified a scissor lift and was using it to elevate steel columns into place. Now, most of us on this call are going to say, well, no, you should never use a scissor lift to raise a steel column into place. We know that a scissor lift is not supposed to be used as a substitute for a crane in this case, right? It was being used to handle material, including but not limited to steel columns. And so OSHA doesn't have, as you know, OSHA doesn't have a specific standard for scissor lifts. They are considered an elevated work platform. You can apply the scaffold standard, but they're not the same as an aerial lift, which does have a specific standard. And one of the complaints that we all have about OSHA is, as Jim Sullivan said, it takes an average of 7 years for a standard to become enforceable, or to become, have the weight of law, right, to be an enforceable standard from when it's first introduced. The longest one I'm aware of is it took almost 20 years to get a confined space standard in place in the industry. I think it was 19 years and some months. And so it's a very slow process. In the meantime, all OSHA has to rely on is the general duty clause violation. In this one, I think we'd all agree that if we saw an employer using a JOG scissor lift as a substitute for a crane, was using it to raise materials into place and then bolt them into place, I suspect everybody on this call would call foul there and say, hey, you're not supposed to do that. We probably mostly agree with this one, right? Now, Jim Sullivan could probably look at the case and see problems from a legal standpoint, but just from a practical standpoint, we would all agree with that one. So let's look at the next one.
I don't see any problem legal standpoint, because remember what we said, is it reasonably foreseeable for a reasonable employer given the same set of facts? That's the test, okay? And as you said, we all know that you don't use a scissor lift this way. When we say we all know, that means that reasonable employers in this industry would never do this, okay? So this is a slam dunk.
And so when I read this, I think that this person, before they opened Yellowstone Construction, they were a Tennessee farmer, because that looks like something we would do. Next slide. Like this one, times prior, employees engaged in guiding steel arch sections with a forklift were exposed to the hazard of being struck by it. While raising the arch upright, iron workers were either under the load or near the ends without tethers, right? A single fiber web sling was attached to the arch on one section, creating an off-centered unstable load. I would guess that fell and injured someone. I would guess that it's probably not a fatality based on the penalty numbers that you see and the dates. But when we look at this, how rare would it be for us to use a forklift to raise a structural steel member or steel member into place and bolt it into place? I don't think that's nearly as rare as lifting steel with a scissors lift. But in this particular instance, OSHA issued a citation. You also notice that they settled it in an informal conference. But the citation stood, and that can be a problem for many of our firms because it makes it hard to compete if you've got a serious violation on your record. And so let's go ahead and look at the next one. The next one, employees working near or above rebar in use as fence posts that were not guarded to prevent an impalement hazard while the employees were bolting up steel working from an aerial lift above it, right? And other employees were walking along the fence on uneven ground. So it's as simple as this. Somebody took pieces of rebar, drove them in the ground, and probably put the orange net wire along that to create an area where like stay out of this area kind of thing. And as we know, rebar can be an impalement hazard. So OSHA issued this citation because they don't have a specific standard for this particular application. Now, I believe there is a standard that says you have to protect rebar, but that's when rebar is being used in the traditional sense of the word, not as a substitute for a fence post, right? Let's go ahead and look at the next one.
Hey, Steve, let me make a comment on that one just to go back.
Please.
People will say, well, wait a minute, I thought you said likely to cause, and how likely is it that somebody would get impaled on this rebar? And that's not where the likely applies. The likely applies only to say it would likely cause a serious injury if it occurred. So the question is, do I have to prove it would be likely to occur? Okay, that is that this particular impalement would occur. And the answer is OSHA has a lot of leeway on that regard because, in fact, even though it's not strict liability and employers have to do what's feasible, when they see something that, like Jim said, is open and notorious like this, it makes sense that they're going to cite because it is something that is easily preventable.
And that one pretty much is.
Yes.
Also notice OSHA settled that and the employer settled it in an informal conference for a small penalty reduction. Okay, let's look at the next one. I like this one. There's a couple things I want to point out to you here. An employee was exposed to a fall hazard of approximately 15 foot to a lower level when he was permitted to work from a sky jack scissor lift while on a slope and while another forklift was being used to level the scissor lift as it was on a slope surface. And then notice this is what more, not so much that we all read that and go, that sounds pretty jacked up, right?
Yep.
That's not something we would normally see. Most of us would cry foul. Most of the people, that are on this call would see that and go, I'm not doing that, right? But these people weren't, obviously they weren't, they didn't see that as a hazard, or as what is more often the case is they thought they would, would be okay. And this is a great novel way to address the situation we find ourselves. What I want to point out to you that's really important, it says, as per the scissor lift manual on page 5, work platform elevation and elevated driving must only be done on a firm and level surface. My point here is to tell you that it's very common for general duty clause violations for OSHA to go into the owner's manual or the operator's manual of a piece of equipment. And if they find that you're not doing something that operator's manual tells you to do, OSHA has this general belief that the operator's manual becomes a de facto standard under the general duty clause. And Jim Sullivan and Jim Stanley will both tell you that there's much more to that, but OSHA issues general duty clause violations frequently when you've done something that's not in accordance with the operator's manual. So 2 things I would recommend to you is that, number 1, that you use and read the operator's manual, right? And number 2, if you're cited for not following it, you probably need to seek out and get some advice from us or someone else that's knowledgeable about, is that entry in that operator's manual truly something that you have to follow under OSHA.
Somebody in the audience might be questioning then, why do they even have to issue a standard if they can just use the operating manuals as the standard?
And the answer is they shouldn't, but they frequently do, right, Jim?
Well, I don't think there's anything wrong with it in the sense of showing knowledge and recognition of a potential hazard. It's just that we do recognize now that they're not going to wait any longer for any specific standard to be issued or passed. They're going to just continue to use the 5A1 in this manner, and there's not necessarily anything wrong with it, except I think when we start talking about things like COVID-19, maybe heat illness, and other things where you're exposed to something in the workplace and you're also exposed to it at home or elsewhere. That's where this use of the general duty clause gets very dicey.
And so I had 4 or 5 items that I wanted to mention before I quit, and I'm going to address one of those right now. One of the reasons as a safety and health professional that Jim Stanley, Jim Sullivan, myself, and many others, we're not a fan of general duty clause violations because they really don't advance the cause of safety and health in the workplace. If you really want to move the needle, you have to do it the right way, and the right way is to propose a standard, to introduce it in the Federal Register, and for it to work its way through the gauntlet that is, you know, the path of OSHA that OSHA has to take to have a new standard. It is not effective for OSHA to issue general duty clause violations because they don't accomplish very much on a national scale, almost nothing really. And so if OSHA wants a standard on heat stress, you know, it's my opinion and the opinion of many others that they should propose a standard, and they should work with the industry and organized labor and groups like yours to reach a consensus and move forward. It shouldn't be that this is how we think it's supposed to be, and we're going to use the general duty clause to enforce it. That is not effective. That is not an effective way to move the needle. Let's go to the next one, and that's just my opinion.
Well, I guess that you agreed with my opinion in Sturgill Roofing then, Steve.
Well, if I was smart enough to read it, I probably would, but I'm probably not that
The
smart.
only one I ever agreed with, Jim.
So just in summary, you know, we did say we'll talk about state plan states. Just a reminder to everyone on the call, there's 22 states and territories that have full OSHA programs. There's 26, probably soon to be 27, that have either full programs or public sector only programs. I will tell you that states are less likely to use the general duty clause than federal OSHA seems to be. That's just kind of a general statement. I think California, Oregon, Washington, they do so frequently. States like Tennessee wasn't as often as that we would necessarily. And also I'd like to point out that it's always clear after the fact that that there was something that could have been done. That always looks real clear after the fact. I think it would be a great case study to see how many general duty clause violations are issued on a general scheduled inspection where OSHA just does a general walk around. I'm going to say it would be less than 10%. I'm going to guess that 90% of the general duty clause violations are issued after something went wrong, either a near miss, an injury, or a fatality. And so that should tell us something about how effective they are. If they only pop up after the fact, how effective is it to issue citations or to try to rectify a situation after the fact? Doesn't do a lot of good in the general sense, right? And so I think that's worth noting. Again, states don't do it. States don't issue those as often, but they all are required to have similar language in their state law when they have a plan, and so that's important. And then lastly, just remember that when you read one of these, and OSHA says you have to do A, B, or C, if you agree that's a hazard and you decide to correct it, you're not going to contest it. Just always know that OSHA said you have to do A, B, and C to fix it, but you don't. You can use your own abatement method as long as it's effective, and you can choose how you're going to address the hazard. You don't have to use the way that OSHA prescribes in their general duty clause citation. They have to put that in there, but it'll almost always say feasible and acceptable abatement methods are, and then say including others. You can fix it the way that you want to as long as that's effective. And so those are my comments. I'm not sure if we have questions now. We've left about 7 or 8 minutes for questions now, and we're happy to stay on. So
we do have questions right now. We're looking at about 5, and like you you say we're up to about 10 minutes left here. First one, how does OSHA set or go about setting the amount of a fine if there is not a standard to go by?
So I'll answer that. It's the penalty is assessed with the same formula and the same section of the field operations manual as any other serious violation. It doesn't have a unique penalty. It's calculated the same way that any other serious hazard would be calculated. And I say serious because OSHA can only issue the general duty clause violation if it is serious in nature, and they can only issue it to the employer of the employee exposed to the hazard. OSHA cannot use the multi-employer citation policy when a general duty clause violation is proposed in a citation. And that's currently just a little bit less than $14,000 per serious violation. If it's not a willful repeat or egregious, it would be up to $14,000, calculated the same way as any other serious.
All right, another one here. Earlier in one of the citations you showed, there was involved a forklift. This person asked, isn't using a forklift, fork truck, or telescoping fork truck covered under subpart CC now?
Yeah, that's a great question. There are cases where it is if it has a hoist, but oftentimes we just lift it and hold it in place with the forks. In that case, it wouldn't be. But we certainly can go to CC and look, because they do have a short section that addresses when CC is applicable to a lift truck.
I have to tell you that there's a specific section of CC that says that powered industrial trucks are not covered as cranes.
All right. Another one, I think someone's looking for clarification. They ask, a 5A1, can it only be used on serious or greater, not OTS? And I'm not sure what OTS stands for. So in a negotiation or reclassification citation, is OTS available in a 5A1?
I will tell you that I know that OSHA has reclassified general duty class. At least I did. There was cases in Tennessee where we did reclassify it as an OTS, an other than serious or non-serious citation, but it can't be proposed that way. And Jim Sullivan or Jim Stanley, you may want to opine on that as well.
Can't be proposed. You've already answered that question because it has to involve serious injury.
But can it be reclassified in an informal conference to an other than serious violation by OSHA? That's really the question.
OSHA can do whatever they want.
Yeah, it's very questionable as an attorney for an employer. I would argue that if I can demonstrate that this should not have been cited, I'm not going to even agree to an other than serious.
Right.
Okay. At what point is employee misconduct or neglect something that an employer can use as a response to a citation?
Well, you can never use neglect. And why is that? Because the OSHA statute only applies to employers. That is to say, employees have no responsibility under the statute for safety and health. Only the employer does. The employee misconduct is a defense an employer can raise affirmatively to a citation, or when it goes to the Solicitor of Labor's office, to a complaint. And you should, if you have instances as an employer, to at least raise this defense. But it's a difficult defense to make out because you just can't say, well, he violated one of our rules. You have to prove that you have these rules, they're published, they're known to everyone, and also that you have enforced those rules in the past with actual discipline. So for example, if I went into a trench and there's evidence that I never enforced the rule of going into an unprotected trench or something else dangerous like that, you're not going to be able to use that as a defense. It's not something that OSHA has to prove. OSHA doesn't have to do anything about employee misconduct. It's something that the employer must prove through an affirmative defense. It's not impossible, but it's difficult. I hope that answers the question.
I believe it does. That's all we have for questions at this point in time. I want to thank all of you for your time and your expertise on the subject. Great subject. Certainly something that is what we're all out facing every day in working with OSHA. And of course, we all want to be safe and work safely and see everyone go home safely. That's the point of these calls. So thank you for your time and your efforts and your expertise. There's letting everyone know that this presentation is going to be available to watch again on the Impact website, as are all of our prior Impact international or national safety calls. So I want to thank everybody for your time. We look forward to our next call, and we're going to have one here coming up soon. So again, thank you, and everyone be safe and take care.
Thank
Thanks,
you.
guys. Thank you.